Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, we're going to take up a criminal matter that I need to address because we have a trial set for Friday. Upon the conclusion of this hearing on the criminal matter, then we'll come back to the Chancery docket. So, we got Mr. Spratt, are you ready for Mr. Vaughn to be brought out? So maybe Ms. Duke wanted to take over as elbow counsel. So.
Come on, Miss Duke.
All right. This is going to be the State of Tennessee versus Sherrick Markey Vaughn. All right, this is the State of Tennessee versus Sherrick Markey Vaughn. We have a number of, he has, I think, 4 different indictments. The defendant has filed a number of motions, some of which are addressing to different of those indictments. The one that I'm going to deal with, Mr. Vaughn, for your information, the only one I'm going to deal with this afternoon is the case that is set for trial on Friday, and that is the docket number 2022 CR 336. Am I correct, General, that that is the state's election to proceed?
Yes, Judge.
All right. So the case that's set for Friday is charge of driving a revoked license, third offense, of resisting a stop, frisk, halt, or arrest or search, and then count 3 is retaliation for past actions. So, well, I don't know, I don't recall you being told specifically which one we're being tried on, but that is the one the state has elected to try on Friday. You have filed motions on that case, and that is the one motion that you filed is the motion that I'm going to address today. So it's your motion, and I will recite. They're all filed in one. Number one, there was a motion addressing all of the indictments that was filed back in March for a request for a bill of particulars. Is that a case that we need to address that motion? Beyond that, we also have your motion to quash or dismiss with prejudice suppression, and that's the one that is specifically addressing 2022 CR 336, which is the case that's set for trial on Friday. So let's start with that motion. It is your motion, Mr. Vaughn. If you want to address those issues, you can come to the podium and argue your motion.
Address one thing before we get into that, just because it will bring some clarity. The state was already planning to go ahead and dismiss count 2 of this indictment, which is resisting arrest. State will continue to go to trial on count 1 and count 3, but that should shorten the argument some.
All right, so the state is moving to dismiss count 2.
Yes, Judge, which is the resisting arrest.
So count 1 is driving a revoked license, third offense, and count 3 is retaliation for past action. Mr. Vaughn, do you understand that the state has moved to dismiss count 2 of this indictment? So you need to turn your microphone on there.
For fruits of the poisonous tree, they need to dismiss the rest of them because that was the reason I was even arrested to begin with.
Well, I am going to let you argue your motion, and
Your Honor, can I get a hand free so I can find my paperwork, please?
you may.
Your Honor, while he's doing that, may I ask, address the court, there was a motion to quash the indictment in this case, and a bill of particulars motion, is that right?
There was a bill of particulars that was filed, a motion for a request for a bill of particulars filed March 27th of 24. And that contained, addressed 4 different indictment numbers, including the one for Friday, 336. The motion specifically addressing 336 is a motion to quash or dismiss with prejudice / suppression. And that was filed July the 7th of 2025.
All right, that's the one you're here to hear today, you said?
That is the motion that I'm going to hear today.
Okay, you said you want me to...
You may.
Your Honor, why wasn't I given notice of today's court date?
Number one, you filed these motions, and this is the first opportunity that we have to hear these motions or this motion prior to your trial date. I'm assuming you don't want your trial date continued from Friday, since you had filed a speedy trial motion.
Yeah, and I'm still stating the same thing on the record, that that is not what we were supposed to go to trial on. The last time I was here, it was for the case in Dickson over with Jennifer's mom. I forget the case number. There you have the case number. She didn't speak about going to trial on this one. The state changed it without giving notice again.
I'm sorry?
I mean, it seems like it's a hindrance to my defense when I don't know what we're going to trial for when I'm coming in here, and I'm told one thing and it's another thing when I get here. And I'm not even giving notice that I'm here today. Like, I wasn't expecting to be here until Friday, and I just filed 2 more motions that would have made it on time within the time limit that's required by the local rules of practice. I got them with me. I'm kind of caught off guard here today. The reason I'm trying to get
What are
understanding.
those motions addressing, Mr. Vaughn?
It was another to recruit Mr. Lee Spratt, and it was another to address these charges here today too, where there was some dismissals back when I first was arrested, and them dismissals still showed up on my Homeland Security report that it caused another arrest in another county. It was a motion to arrest judgment on that. That's yeah. So I feel like I'm getting caught off guard here.
Well, your motion to dismiss or quash was filed, and this case is going to trial on Friday, so I have to hear it before the trial. To not do so would basically mean that your case would have to be continued, or you'd have to waive your motion.
No, I'm in full understanding of that. Yeah.
I'm trying to give you an opportunity to have that heard and make a ruling on the record of it so that, you know, you preserve the issue prior to the trial date on Friday.
Okay, do you also have a motion for chief evidence up there with you?
A motion for what?
For the state's evidence in chief?
I think there is a motion such that you described, but it is not addressing this indictment number.
I should have one for all of them, and including with this, is the state not required to respond to me? Because I've responded way before the state responded. She didn't even give me a response to this motion. I'm just filing this, and
The state does not have to respond to the motion until they come to court. They can then respond on the oral argument.
And then
You
I
do-
can have a response after that, correct?
Yeah, I'll give you a chance to respond after they do.
Okay.
But you do have a motion to preserve testimony or a motion to subpoena someone, and that is to subpoena Jennifer Dozier
Yes.
from Savannah, Tennessee. Was there a subpoena issued for Ms. Dozier in regards to his? Well, he had requested that there be a subpoena issued for Jennifer Dozier to make her testimony at the motion hearing date. All right, let's let you go ahead and argue the motions that you feel like are, there is a motion to preserve testimony or motion to subpoena that was filed again on July the 7th, and you've included all three of the case numbers on that.
You said which one was that, Your Honor?
The motion to preserve testimony or motion, and then slash motion to subpoena, then you have a matter that you filed again on July the 7th called judicial notice. And this is where you're complaining about the discovery being delivered to the jail administrator rather than sent to you directly. And then we have the motion to quash or dismiss with prejudice.
That was Jennifer Dozier. Your Honor, can I go back to the table? Because all my paperwork's over there.
You can do that.
Is it in that order?
We'll let microphone towards him so that we can make sure that he's picked up on the record. All right, did you see what you needed to see? All right, I want to deal with all of the issues that relate to 336 that are set forth. First one is the motion to preserve testimony or to subpoena this witness. So let's deal with that one first.
I'm ready when you are, Your Honor. I'm sorry. I believe that's fairly easy. I don't
Push
need to
that
see-
base of that microphone towards it.
Can you hear me?
I can hear you.
Okay. You're fine with me arguing from here, correct?
Yes.
Okay. I'm not seeing my motion. All right, hereby I, Cedric Vaughn, come to move the courts to subpoena Jennifer Dozier. I have her phone number, which is listed. Her address is also listed to preserve testimony in the above case and motions to dismiss. She has first knowledge on each pending case. I move the courts to subpoena Jennifer Dozier and make testimony at the set motion hearing date. This is the motion I filed for you.
Okay, why do you need Jennifer Dozier subpoenaed?
Well, Jennifer Dozier is the mother of my children, and we were also living together. And every time I was arrested, she was present at every scene, and she can verify to my testimony of each case, like the illegal arrest, non-resistance, illegal search and seizure, twice and two separate. She can testify to every single thing that I'm saying, stating.
All right, in regards to the case on Friday, which is basically a driving on a revoked license, third offense, and retaliation for past action, how does her testimony factor in on that, on those two charges that we're dealing with on Friday?
On those two charges, I mean, it would still, I would say it would still tally in if we add back in the charge they're moving to dismiss, because like the motion states itself, that it'd be fruits of a poisonous tree, that they need to dismiss it because it was a illegal arrest from jump. I should have never been put in handcuffs or arrested or nothing. And she would testify, I never resisted or anything. To take that one charge and just press it to the side and then keep the rest, it'd just be unlogical.
Well, I understand what you're saying, that she may have been present during some of the proceedings, but is she going to be able to testify about anything that has to do with whether or not you were driving or not driving a motor vehicle while your license was revoked?
I feel like that's a trick question, Your Honor.
Yeah,
feel like you're probably
is.
trying to perjure me, aren't you?
It probably is a situation where you don't, because you're representing yourself. Well, obviously, we cannot get a subpoena issued and served on her at this point in time. Do you have any contact with her?
I do, and she would be a material witness, Your Honor.
And being a material witness, then you would be entitled to a continuance for the case on Friday if she's not present.
How long is this continuance, Your Honor? I'm so tired of these cases. I don't want it to be out months at a time again.
Let me run through this. Right now, do we have State versus James Wills? It is a go. State versus Hansard.
So there might be another.
Is the Wills case going to go more than one day? So the Warren case is the one that I have the motion under advisement, but it is still set for trial.
What day did you say?
State versus Sarah Fuson is still go. So we could set Mr. Vaughn's case for the 25th. September 25th.
Are you back from vacation?
I'm trying to think, Your Honor. I also have Decatur coming up.
Decatur's on September the 30th. I just got it.
It's the 30th? Okay, that'll work. Is there any way we can also add in this other motion about getting heard about the Homeland Security stuff that was supposed to be dismissed?
Well, that really doesn't have any relation to what I'm doing today. What I want to do is deal with what I have to on this case, and then we'll set you another day for arguing the motions, because I just brought you in on a day when I'm supposed to be hearing chancery matters, which are not criminal, and I'm doing this in order to expedite the disposition of these motions. So what I'd like to do is to stick with the motions regarding this case and go from there. And if we're going to have to continue it anyway, then we can set all of the motions on, how big is the docket on the 22nd? About 49 pages.
And Judge, I will be here that morning, but I'm leaving at your lunch break.
Okay.
Could you do
Yeah.
it Friday morning?
What about, since we're not going to be able to go to trial, General, what about having the motions for Mr. Vaughn's case heard on Friday, the day we were going to try the case?
I can do that, Judge. I'm trying to work around. I've got several officers that are no longer in law enforcement. And so would you be looking at putting this for trial on the 25th?
We would be setting the case that you want to proceed on, 336, for trial on the 25th. What I'm trying to do. He has requested a subpoena to be issued from Ms. Dozier. He is entitled to have that witness subpoenaed. I don't find that there was one, even though I think it was probably just a series of motions that got filed and it just got overlooked. So I want to give him an opportunity to bring this witness in, to have her testify if he thinks it's relevant. So.
Judge, I think I should be able to move all of my witnesses around. I would ask if we can agree that if a witness is out of town or something else, that they could appear by Zoom to testify, which would keep us from having another continuance, but still have witnesses available. Because I can't stop right now and see if everyone I've got is available if we
But again, this is only going to be on the 25th for this case 336.
I understand. I've got one officer that is working in Cleveland. I've got another that is self-employed. I've got to work around a couple of different things.
On the 26th, we have a sentencing in the second-degree murder case of Curtis Day, correct? Sentencing, Hansard Rule 412 motions, State versus Sheets motion to dismiss, to suppress. Hicks and Long.
That's me.
Well, my only concern is trying to set this case for the 25th and hear the motions on Friday. Can we at least agree to set the motions on Friday?
Yes, Judge, I have one officer that is present today that will be unavailable on Friday. Could we go ahead and preserve his testimony today?
Yes. I'm going to move your motions to Friday to give a chance for you to get in touch with this young lady that you want to have brought in and see if she will come voluntarily. And I'll have the clerk go ahead and issue today a subpoena for her at the address that you've shown in your motion. But they may not be able to get it served on her, but if you'll contact her, she can be served with it if she'll voluntarily appear. And we can set your motions for Friday.
Yeah, that's frustrating, Your Honor. I mean, these motions been in. I mean, it makes no sense. I mean, she's prepared, but I ain't.
Well,
That's very frustrating.
resetting it to Friday is going to give you a chance to
I
prepare,
mean,
and you know which
it is,
ones.
but it ain't. It is, but it ain't. I mean, these motions been filed for 4 months. I mean, I don't understand why people just can't read the paperwork and do it.
Well, even by the record, they were filed July the 7th, so they're not been filed 4 months. Let me go ahead and just say that we're going to continue the motions to the to the 19th this Friday, and we're going to have the trial moved to the 25th. If, General, you may file your request to have a witness appear by Zoom according to the rule, and we'll have a hearing on that on Friday as well.
Well, if that's the case, Your Honor, can we go on ahead and get my other one added in too? I mean, because the reason I keep asking about this motion, this pertains to me in Decatur.
Oh,
I
let's
mean,
just hear all your motions on Friday.
That sounds good.
In every case, Your Honor.
Pardon?
In every case.
On every case, we'll hear every motion he's got.
That sounds great. That's great, Your Honor.
Your Honor, may I ask, was count two?
Count 2 is dismissed on the state's motion. They've nollied it.
Counting this one.
Day versus Wills, is that? I did a motion hearing on that, didn't I? Name is familiar.
Yeah, count two.
Yes, go ahead.
All right, thank you.
I'm
Your Honor.
going to go ahead and I'm going to switch gears and go to Chancery for a few minutes, and then I'll come back to you. But I know you've got an officer that needs to be heard, and we'll try to do that as quickly as possible. Okay, are we ready to proceed on Mr. Vaughn? Bring it up, Mr. Vaughn.
Judge, I need to update the court as to a procedural matter in this case.
Pull that microphone towards you a little bit.
Okay. Judge, I need to update the court as to a procedural matter in this case. Mr. Vaughn, in several of his motions, was asking about booking, and it occurred to me to double check something. So when this case was originally charged by warrant in June of 2022, the resisting and the driving on revoked were charged by warrant. The retaliation for past action was not added as a charge until grand jury, which was in October of 2022. Because we did not modify the bond, there was no new book-in at that point. I've not pulled up yet to see when he was arraigned, but he was later booked in on that charge February of 2024, when he was booked in on everything coming into custody altogether. But the booking may have been after the initial arraignment, which was what I wanted to alert the court.
According to the docket sheet, he was arraigned on November the 30th of 2022, and that the plea date was set for April 3rd of 2023, trial date of April 6th of 2023. And that was, he had an attorney on November the 14th that filed a waiver of personal appearance by Mike Flanagan, his attorney at the time. All right. Then we're ready to go forward on the preservation of testimony regarding the motion that Mr. Vaughn has filed.
Yes, Judge. Is there any need to rearraign him at this point?
Not that I'm aware of.
Okay.
The booking process is something that occurs at the jail for a person to be booked and processed according to the sheriff's department's records. This court speaks from its record, and this record is from the docket sheet, and the indictment that contained all three of those counts was arraigned, he was arraigned on that in November of 2022. Plea of not guilty to all of those was entered. He had a waiver of personal appearance also by his attorney at the time. So I do not find that there is any defect in the issue of the validity of his arraignment, because he had an attorney that waived the reading of the indictment, and this has never been an issue that's been raised up till now. So for that reason, the fact that he was or was not booked on count 3, he was booked on the original charges and when he was taken into custody. So.
Judge, I realize we are not arguing the full motion, but so that you may receive this testimony in a meaningful way, I would like to give this court a very brief sort of factual summary of this case.
All right.
Judge, law enforcement came in contact with Mr. Vaughn while investigating a call out that Mr. Vaughn was the driver in a vehicle. In the vehicle was Ms. Dozier, who you've heard about today, as well as their 2 children. The officer asked to speak to Mr. Vaughn separately, and he refused several times. Ultimately, she opened the door and escorted him out of the vehicle. That was the basis for the resisting charge that was originally the reason for arrest. It was later found out that his driving license was revoked, and that charge was added since he was driving the vehicle. Now, once he was at the jail, he made several statements to law enforcement that are the basis for the retaliation for past action. And when we have the hearing, you will hear the bulk of those from Officer Javins. We do want to preserve the testimony of Lieutenant? No, Sergeant, I'm demoting you. Sergeant Stewart, because he will not be available on Friday. And so that he comes in after Mr. Vaughn has been arrested and is present in the jail and has already made some statements to Officer Javins, which you will get at a later date.
All right. You may call your witness. You may.
Clarifies to the matter the court ruled on.
You'll come to the podium.
Yes, sir. So the arraignment, and Mr. Flanagan waived the arraignment. I just want to clarify for the record that his bond was revoked, I believe, on all these cases in July of 2024, I believe.
July 24th of 2024, the defendant failed to appear in court. Present was the DA and his attorney, Lee Spratt. Mr. Spratt spoke with the bondsman. The bondsman could not find the defendant, issued a capias and hold for a hearing. Final forfeiture was set for January 17th, 2025.
And the capias was served. I just want to make sure that, for the record, that he's never been booked on count 3, that in the event that we get to a point that he's going to get jail credits.
And I would only point out to you that when the indictment came forward with a third count that he had not been booked on, there was no increase in the bond. So the bond that was revoked was the same amount that was put in place at the time he was arrested on counts 1 and 2. So there was no change in the bond. And I agree there might be an argument to be made about the booking process if in fact he had been arrested on a higher bond because of that third count of the indictment.
Yes, sir. Thank you,
All right.
Judge.
Then, General, you may call your witness.
State would call Sergeant Justin Stewart. Did I get it right? Sergeant.
Sergeant, if you'll come forward, we're going to put him over here.
Are you Sergeant Justin Stewart?
Yes, ma'am.
Would you spell your first and last name for the court reporter, please?
Yes, ma'am. First name Justin, Justin. Last name Stewart, Steward, and David.
And Sergeant Stewart, were you employed by the Dickson Police Department on June 18th, 2022?
Yes, ma'am.
And during that evening, did you work a call involving the defendant, Sharik Vaughn?
Yes, ma'am.
And you continued working that shift afterwards?
Right.
And you went to the jail for another call?
Yes.
Or after another call?
A warrant service. Yes, ma'am.
And at the jail later on that night after his arrest, did you encounter Mr. Vaughn again?
Yes, ma'am.
Could you explain to the court what happened?
So at the time, I can't remember if I was a field training officer or a corporal, but either way, I had a recruit with me, Officer Floyd. We made an arrest later in the shift, and while we were at the jail to deal with our arrestee, jail staff pulled Mr. Vaughn, I believe, out of the holding cell he was in, and he was upset still at that point, agitated, and he made a statement. Something to the effect of, I've got bullets for all of you, or enough bullets for all of you, et cetera. So I just mentioned to Officer Javins when I returned to the police department that was worth notating in her report, just in case in the future, if she were out in public, he were to, attempt to follow up on those threats, the documentation would be there that they were made.
Nothing further, Judge.
Mr. Spratt or Mr. Vaughn, either of you have any questions for this witness? Come to the podium. And I would, again, Mr. Vaughn, I know you are pretty well acclimated to the law about a lot of things, but you must ask it in the form of a question.
Yes. Give me a second. How long ago was this case, Mr. Stewart?
2022, it's been a while.
2022. So you have full, you remember, have no problem remembering what happened?
Yes, as I said, me saying it, the phrase or the terminology of enough bullets for all of you, or names on bullets or things like that, I'm not 100%. I do recall it being concerning enough that I went back and told my officer to document it just in case you actually meant it and weren't just, upset in the moment, and may actually try something later.
So
right?
that's what you're standing, you're sticking to it? Like
100%.
you're fully remembering
Absolutely,
that?
yeah.
Do you have any video footage of this?
So we're working on that right now. We initially thought that my video footage was tied to Officer Javin's original case with you, with the traffic stop. And then it was learned recently that, no, in fact, my footage was not from me being present for her case. It was a separate case that we had afterward while Officer Javins wasn't at the jail.
So you don't have any footage?
Of my own body cam at that time, no.
Okay. Is there any jail footage that you know of?
I'm not sure. I know, as I said, Officer Floyd was there with me, and then, of course, some of the jail staff would have been present.
Okay, and you said they pulled me out of the cell, and I made these statements?
If I'm not mistaken, I know you were standing in the area in front of what is now Male Detox 2. They have a blue square on the wall to photograph people. I don't remember if they had just pulled you out, but I remember you being out of the cell in the open there when it was set.
Okay, I rest, Your Honor.
Yep.
Go
I have a
ahead.
moment, Your Honor.
Yeah, consult with your co-counsel.
I didn't catch your rank. Is it
Sergeant. Yes,
Sergeant
sir. That's
Stewart?
fine.
I'm sorry. I always want to clarify. You said that he was pulled out of the cell and made the statement, "I got bullets for all y'all," right? And that's exactly how he said it?
Yes, sir.
Okay, so he never mentioned Officer Javen specifically then, did he?
I don't think he explicitly stated it was her. It was
Okay.
just law enforcement.
All right, so, well, did he say law enforcement?
The only other people in there would have been law enforcement, so I just logically, yes, sir, that's who he's talking about. All right.
But none of them are named in this indictment, correct?
I don't believe so.
Okay.
Anything else, General, for this witness?
No, Judge.
All right, thank you, sir. You may stand down.
Thank you.
For the purposes of the hearing today, we were preserving all of the other motions for Friday, and this was only to allow Officer or Sergeant Stewart to testify and preserve his testimony to be considered by the court at the hearing on Friday. So if there's nothing else, then we'll adjourn this case until Friday. Mr. That's a good question. I'll allow you to review the file and make that determination.
Your Honor, one more. Would you consider those motions that you probably haven't received yet, consider those as moot? I have, except the motion of indigency. You can keep that one. I just don't want to add no more time to the fast and speedy trial. So if we can't get them heard, I just want to consider them as moot.
If you have motions that you're going to file, make sure that Mr. Spratt assists you in filing them, and we'll have everything heard on Friday.
They're already considered filed by the rules, sir. Once they're put in a correctional facility now, they're considered as filed.
You want what?
Considering the Rule 49, they're already considered as filed. I'm just trying to get them considered as moot today.
Well, I'm not hearing anything else today to allow you to have an opportunity to prepare everything to be heard on Friday. Since the trial date is being moved, we're going to give you the whole day of Friday if necessary to hear your motions.
All right, thank you.
All right. Anything else before we adjourn? All right, and we stand adjourned tomorrow morning at 9 o'clock. We'll have Chancery resuming again, so we'll hopefully only have Chancery and not